The test used by courts to determine the impact of contradictions or inconsistencies on the prosecution's case is a substantive one. It requires the court to inquire whether the contradictions or consistencies were so material to the issues in question that they would deal a fatal blow to the prosecution case. In the case of Eric Onyango Odeng versus Republic, the Court of Appeal held that minor discrepancies and inconsistencies in the evidence of prosecution witnesses were natural and inevitable, where different witnesses recounted the same events from different perspectives. Such inconsistencies would not render the prosecution's case unreliable unless they were material and go to the root of the charge, or that they created reasonable doubt as to the guilt of the accused, or demonstrated deliberate falsehood. The Court of Appeal guided that only grave and unexplained contradictions that affect the substance of the prosecution's case may justify rejecting the evidence. I have keenly considered the contradictions which the defense has made very heavy weather of during cross-examination and in their submissions. I find that the contradictions in the evidence of PW9 and PW38 mainly related to whether the second accused boarded the vehicle at the hotel, whether the vehicle had music, and whether the late Sharon expressed distress when the vehicle was on transit. In my opinion, these contradictions related to peripheral matters that did not go to the root of the prosecution case. With respect to the contradictions in PW9's evidence, PW9 explained that he had described the subject vehicle as dark stroke black because he had seen it at night in circumstances that did not allow to see its color properly. This explanation in my view is reasonable and does not. This explanation is, in my view, reasonable and does not indicate or is not evidence of any dishonesty or untruthfulness in the evidence of PW9, because even considering ordinary circumstances, Calagre fits the description of dark. Considering that even in ordinary circumstances, Calagre fits the description of a dark as opposed to a bright color like white, cream, yellow, orange, or whatever other bright color you can think about, and may look like black whenever viewed in the darkness. In any event, it is common knowledge that a vehicle is identified through its registration number and not through its color. In my considered view, the contradictions in PW9 and PW38's evidence were not fundamental to the key issues in question in this case and were thus not fatal to the prosecution case. Regarding the challenge on PW9's and PW38's credibility, contrary to the defense's submissions, I find nothing on record that would cast aspersions on the credibility of these witnesses. I watched the witnesses as they testified, and in my view, they gave clear, detailed, and consistent eyewitness accounts of the events that took place on that September 2018. The second accused facilitated execution, where the third accused ensured logistical support and concealment to avoid detection of the offense. Inherent in these roles were acts of preparation and concealment, denoting knowledge, participation, premeditation, and intention to execute. Their common intention aimed at executing their common intention that ultimately led to the death of Sharon. These acts constituted malice aforethought as defined in Section 206 of the Penal Code. The fact that the first accused alibi that he was not in Migori County at the time the offense was committed, and the same was vindicated by the evidence that was produced in this case, and that he was in Nairobi from the 2nd of September all through. Even from he was in Nairobi from the 2nd of September. It was not therefore physically in Migori when the offense was committed. That's not meaning that he was not physically present in the place where this offense was committed. Does not shield him from criminal culpability, since under the doctrine of common intention, criminal liability does not depend on who physically commits the actus reus, but whether the accused acted in concert with others to execute an unlawful purpose. Applying the legal principles governing the application of circumstantial evidence to the present case, and having in mind the law regarding the definition of principal offenders as stipulated in Section 20 of the Penal Code, I am satisfied that the circumstances presented in this case, taken cumulatively, form a chain so complete that there is no escape from the conclusion that the accused persons, jointly with others not before the court, committed the offense charged. The evidence on record irresistibly points to the fact that the accused persons with malice aforethought unlawfully caused the death of Sharon at the material time. It is therefore my finding that the prosecution has proved its case against the first, the second, and the third accused persons beyond any reasonable doubt. I consequently find each accused person guilty of the offense of murder, contrary to Section 203 of the Penal Code, as charged in Count 1. Each accused is accordingly convicted under Section 322 of the Criminal Procedure Code.
We are most obliged.
Most obliged.
Most obliged.